Howdy, my name's Brian Foley. I'm a criminal defense lawyer in Conroe, Texas, and I represent folks who've been accused of a crime in Conroe, the Woodlands, Houston, and that general area. Today we're going to continue our lecture series on the Texas Rules of Evidence. Rule 405 is today's rule, and it is called Methods of Proving Character, Reputation, or Opinion. And that is because there are two main methods of proving character of a witness in Texas, and that is by reputation or opinion testimony. So what is that? That's what this rule kind of spells out. In general, when evidence of a person's character or character trait is admissible, it may be proved by testimony about the person's reputation or by testimony in the form of an opinion. And on cross-examination of the character witness, inquiry may be made into relevant specific instances of the person's conduct. Okay, that's section 1 on the rule, general. And those specific instances of conduct, those are the have you heard or did you know questions. We'll get to how that works in a minute. Section 2, accused character in a criminal case. In the guilt stage of a criminal case, a witness may testify to the defendant's character or character trait only if before the day of the offense, the day of the alleged criminal offense, the witness was familiar with the defendant's reputation in the community or the facts or information that formed the basis of that witness's opinion. And this is because, you don't want somebody saying, oh, well, 3 days after this offense was committed, this burglary, he was super nice and did all this community service, and I think he's a great guy. It's like, well, they had sort of this motive to complete that community service maybe afterwards in anticipation of the litigation. So they have a rule, if you're going to be in the guilt stage, because remember the guilt stage is where you determine if there's sufficient proof beyond a reasonable doubt that the person committed an offense. At that point, then character witnesses can only talk about what happened prior to the original offense. If it's the punishment stage, then it's kind of fair game. Anything you know about this guy, anything that's proven to be good, bad, mitigating, whatever it is, you can pretty much talk about it in the punishment stage. Okay, so section 2 has a subsection B, by specific instances of conduct. When a person's character or character trait is an essential element of the charge, claim, or defense, the character or trait may also be proved by specific instances of the person's conduct. So if their character is actually an element of the offense or the non-criminal case, if there's some tort that says they were acting in a certain way, you could use specific instances of conduct to do that or to prove that. So what is the deal with this rule? Why can't you get into these specific instances of conduct? You could kind of call this, they call it the reputation and opinion rule, but it's more like the anti-specific instances of conduct rule, at least for the person who's offering the character witness. This is because you don't want to just be able to call somebody's mom to the witness stand and talk about every good thing they've ever done. I saw this happen in a trial once, and they called the mom, and they were talking about this person won the Spirit of the Wolf Award, and it was like for a middle school or something like that. It was just totally irrelevant to what was going on in the trial. And so this is sort of like an anti throwing the kitchen sink of he's a good guy, don't convict him in there. Now, you can offer evidence of good character on somebody's behalf, and a reputation or opinion type testimony is how you do it. So what is reputation evidence? Well, reputation evidence is actually testimony that is specifically based on hearsay. So, an expert witness is a type of witness that's allowed to base an opinion on hearsay. But if you're doing a reputation one, there's no other way to do reputation evidence other than to say, look, so-and-so witness, do you know who John Doe is, the accused in this case? Why, yes, I do. And, how long have you been in this community? Oh, for 25 years. I'm a former judge in this community, and I, own a business and blah, blah, blah. And are you familiar with his reputation? Well, what does that mean? That means you've talked to other people in the community. You've heard what other people say about him. Because I'm not asking you what your opinion is, right? If it's an opinion testimony. That's different from reputation. Reputation is everybody else's opinion that you know through hearsay. Opinion is your opinion, and so that's kind of the difference there. So this is one of the only times you can offer evidence from a lay witness, non-expert, and rely on hearsay, and you kind of have to, because that's what reputation is. Okay, so let's give you an example. Let's say a little old lady that the defendant helped cross the street, okay, is coming into court. That little old lady would not be able to say that the defendant has a good reputation in the community if all she knew about him was that he helped her cross the street that one time, right? She could offer her opinion about his character for lending assistance to people who are in need. Let's say, for example, if he was charged with a failure to stop and render aid, like got in a car accident, fled the scene, person needed to be helped or assisted to the hospital, something like that. Well, you could say, well, it's my opinion. I met him prior to the day of the wreck, and it's my opinion that he would help somebody in need, right? That's what the little old lady could say. She could give that opinion as to the good character. She would not be able to go into the specific instance of conduct. She wouldn't be able to say, he held my hand so sweetly, and then he gave me a cookie on the other side, what a great guy. All that crap, that's not coming in. But on cross-examination, the prosecutor could say, well, have you heard or did you know? And he could say something like, well, have you heard or did you know that he watched his own brother drown and didn't help him? And if that was true, then the prosecutor could ask that. There's a Supreme Court case that says prosecutors are allowed to strike hard blows but not foul ones. And so a prosecutor's not allowed to make up evidence. They have to have a good faith basis to believe that the question is true. And so they could say, well, a little old lady thinks he's such a helpful person. Did you know that he watched his own brother drown and let him do it? If she says yes, then you get to say, well, does that change your opinion as to his character? And if she says no, then what good is her testimony, right? If that's the case. So that's how that's attacked. And then all these reputation and opinion character issues come down basically more to the reputation of the person. You go into a little bit of background with the person you put up on the witness stand, and if they're an upstanding citizen, seems like they wouldn't stick their neck out for a loser, right? Then at that point, you're going to have a positive result from the jury. They're probably going to believe this person. They're going to believe that maybe your defendant, is a person of good character. So let's talk about timing now. That is, again, the timing issue here is you have to be aware, if it's a criminal trial, that the thing that makes your reputation or your opinion, all those either hearsay that you heard or things that you directly observed, those all occurred prior to the day of the offense. And we're going to do one case here on point, an example. So evidence that a defendant passed a drug test is not admissible as a specific instance of conduct because drug use is not an essential element of the offense of possession of a controlled substance. That is Areola versus State, a case from the Texas Appellate Court's May 24th, 2012. And that is case number, if you're looking it up through the regular state system, III 00263CR. And thanks so much. I hope you guys enjoyed this. If you liked the video, share it with your friends. Click that like button, the subscribe button, turn on the bell for notifications. You'll be notified every time I drop a new video. And thanks so much. Appreciate your time. And as always, these are for educational purposes only. And if you need help or advice with a case, call a lawyer. Don't just watch this YouTube video and go into court. That would be a criminally bad idea.